Chapter for Thursday, January 13th. First thing on the agenda, do we have any committee bill introductions? Do we have any introductions in the audience? Go ahead, Jason. Actually, can someone take notes? Michael's not in here. I don't know where he went. Okay, go ahead. Yes. Go ahead, Senator. We don't want to waste your time here. Senator Bowers, you.
Good morning. There we are. Good morning, committee. I do have a bill introduction. It's RS 2525, and this is the election security bill that voting machines cannot be connected to the internet, basically.
Okay, I'll make the motion. Senator Hildebrand seconds. Without objection, it'll be introduced. It's introduced. Go ahead, Jason.
Thank you, Mr. Chairman. Jason Watkins here on behalf of the Ruffin Companies. I have a request for a bill introduction that is 22 RS 2433. Deals with the Parimutuel Act and historic horse racing machines.
I'll make the motion. Senator Hildebrand, do you second? Without objection, it's introduced. Thank you.
Thank you, Mr. Chairman.
Okay. Are there any further bill introductions? Not seeing any. We'll go ahead and move on to our presentation today. I wanted to talk about the 2021 enactment changes of the election law. Jason's going to give us an overview of the election law, some of the stuff we passed and where we're at. So Jason, you want to go ahead and start your presentation?
Sure, Mr. Chairman. Thank you, Mr. Chairman, members of the committee. You should have at your seat a memo from our office on the 2021 election law changes. The legislature passed two bills last session, House Bill 2183 and House Bill 2332, both making several changes to the statutes governing elections in the state of Kansas. Both bills have been the subject of legal challenges, and I'll review those with each bill's provisions as well. Starting with House Bill 2183, first, the bill created the Transparency and Revenues Underwriting Elections Act. This is now codified at 25-2436. And the statute prohibits election officials from accepting or spending any monies received from a person except as provided by acts of appropriation or as otherwise by law. So they cannot receive private donation money and use that in the conduct of elections. There are exceptions for monies received for payment of fees or costs assessed by election officials and for campaign contributions for the candidates for county clerk. Violation of this statute is a level 9 non-person felony. The bill also creates an election crime to prohibit what is commonly referred to as ballot harvesting. This is 25-2437 now in the election code. The statute requires that if a person is going to transmit or deliver another voter's ballot to the polling place or the county election office, then there must be a sworn statement by both the voter and the person delivering the ballot that the person is authorized to deliver the voter's ballot and that no undue influence has been exercised on the voter. There is a statutory limit of only 10 ballots that can be delivered on behalf of another voter. There is a strict limitation on candidates for office that they cannot deliver another voter's ballot except if they're an immediate family member of the candidate. Failure to obtain the sworn statement is a level 9 non-person felony, and violation of the 10 ballot limit is a class B misdemeanor under the statute. Third, there is another election crime created by House Bill 2183. This is false representation of an election official. It is codified now.
Hang on 1 second, Jason. Do we not have the pass handout on it, or? Okay, it's this one?
It's down inside. Yeah.
Okay, got it. Okay, go ahead, Jason. I'm sorry.
No, that's fine. As I was saying, the false representation of an election official occurs when a person represents themselves as an election official, engages in conduct that gives the appearance of an election official, or engages in conduct that would cause another person to believe they were an election official, and violation of that is a level 7 non-person felony. The fourth thing the bill does is create a new reporting requirement for the Secretary of State. The Secretary is now required to publish a report each month on the Secretary's website on the total number of registered voters in each county, the total number of voters who have been identified as having mail that is undeliverable, and the percentage of such voters compared to the total number of voters in that county, and the total number of voters of each political party in each county. The statute also requires the Secretary to publish the total number of voters in each voting precinct and the number of such voters registered with a political party on the 10th day prior to any election. This is basically a information publication on voter registration requirement. House Bill 2183 also amends several of the statutes regarding advanced voting ballots. These are the ballots that you receive in advance of an election day and mail into the county election office. The First Amendment prohibits candidates for office from assisting a voter in marking an advanced voting ballot or signing an advanced voting ballot. That is a Class C misdemeanor. The other next amendment requires county election officers to verify the signature on the advanced voting ballot matches the voter signature that they have on file. The statute requires the county election officer to attempt to contact the voter if there is a discrepancy in the signature. If the signatures don't match and cannot be reconciled, then the ballot cannot be counted under the new provisions. The bill amends 25-1128 to add a new provision to prohibit any person from backdating or otherwise altering the postmark date on an advanced voting ballot. That provision, a violation of that provision, is a level 9 non-person felony. The bill also amends 25-1132 to require advanced voting ballots be returned by the last mail delivery of the U.S. Postal Service on the 3rd day following the election. Under previous law, the Secretary of State had the discretion to extend that deadline if necessary. That discretion was removed under House Bill 2183. And then finally, House Bill 2183 amended the electioneering crime to prohibit a candidate for office from touching or handling another voter's ballot, distributing or counting ballots, hindering or obstructing a voter from voting or entering or leaving a polling place, or hindering or obstructing any election board worker. This would obviously not apply to the Secretary of State or any county election official, or any candidate who is transmitting an advanced voting ballot in accordance with the statute. Violation would be a Class C misdemeanor. As I noted, there is a legal challenge filed in Shawnee County District Court challenging 3 provisions of House Bill 2183. The provisions that were challenged was the limit on the ballots that can be delivered on behalf of another voter. Then they also challenged the crime of false representation of an election official, and there was a challenge to the signature match requirement on a ballot. And the challenges generally were violations of the constitutional rights to free speech, free assembly, and the right to vote. I will note the plaintiffs requested a preliminary injunction to prohibit the enforcement of those provisions, and that request was denied by the district court. An appeal has been filed from that decision, and we're awaiting further work by the appellate courts. With that, Mr. Chairman, I'd be happy to stop for any questions on House Bill 2183.
Do we have any questions? Senator Hosher.
Thank you, Mr. Chair. Thank you, Jason. In regard to Section 1132, require advanced voting ballots to be returned by the last delivery day of mail on the 3rd day following the election. And previously, the Secretary had discretion to extend the deadline if necessary. So let's say there's some type of natural disaster a couple days before an election, what have you, that potentially would hinder ballots arriving in time. In the past, the Secretary had discretion to, sounds like, extend the deadline. Where does that fall now? Or is there any availability in that type of situation?
The statute is fairly absolute now that they must be returned by the last delivery by the U.S. Postal Service on the third day following the election. There's no authority granted to any government official to extend that deadline under the statute.
Any further questions? Okay, go ahead, Jason.
Okay. The other bill passed last session was House Bill 2332. This bill created a new statute. It's now codified at 25-125 that prohibits the governor and the judicial branch from modifying election laws and procedures. There is the caveat in the statute that the judicial branch's constitutional powers as the judiciary are not compromised by that prohibition. They can still rule subject to the constitutional powers on election laws, but it does prohibit modifying election laws and procedures. It also prohibits the Secretary of State from entering into any consent decree or other court agreement in a legal challenge to election laws regarding the enforcement or alteration of election laws unless that agreement is approved by the Legislative Coordinating Council. Second, the bill created a new statute requiring county election officers to record and maintain both a residential and a mailing address for each registered voter, and the residential address must correspond to a physical location where the voter resides. Third, the bill made several amendments to 25-1122. This is a statute governing advanced voting ballot applications. First, new subsection K requires that any person who's mailing an advanced voting ballot application to a voter and they are not a county election official has to include a clear label on the outside of the mailer that identifies the name and address of the person or organization sending the mailer, their chief executive of their organization, if any, and the disclosure that the mailer is from a private individual or organization. The application that's sent must be the official application that's provided by the Secretary of State, and no portion of the application can be completed prior to mailing it to the voter. The mailer must include an envelope for returning the application to the appropriate county election office for the voter. And there are, as I said, exceptions. This does not apply to election officials. It also does not apply to the Official Protection and Advocacy for Voting Access Agency, designated for the state of Kansas under the Federal Help America Vote Act of 2002. That's an agency that works in conjunction with that federal act and to educate voters on their options for voting. But any other individual who does not meet those requirements is potentially guilty of a Class C misdemeanor. The bill also creates new subsection L that requires any person mailing an advanced voting ballot application to a voter to be a resident of Kansas or their business be domiciled in Kansas. And violation of this provision is a $20 civil penalty for each instance. So each application that is mailed would be a separate violation. Finally, the bill would expand the crime of election tampering. The crime now includes changing or attempting to change, alter, destroy, or conceal any vote, changing or attempting to change any vote by manipulating voting technology or knowingly producing false vote totals. Violation of the crime is now a level 7 non-person felony. This bill has also been challenged. That legal challenge was brought in the Kansas Federal District Court, challenging the provision that prohibits completion of any part of the advanced voting ballot application under subsection K, and the provision in subsection L that requires the individual mailing the application be a Kansas resident. Both of those provisions were challenged, and there is a preliminary injunction issued by that district court enjoining the enforcement of those two provisions currently. With that, Mr. Chairman, I'd be happy to answer any questions on that bill.
Questions? Senator Hosher?
Thank you, Mr. Chair. Thank you, Jason. In regard to section 1122, any person mailing an advanced voting ballot application to a voter, on the second page, on the bottom there, it spells out all the different things that have to happen if an organization or individual is mailing out an advanced voting ballot application. This top of the second page says, though, that those requirements do not apply to the secretary. And all of those requirements, or because it is also spelled out that the application must be the official one provided by the secretary. So can you tell me what tangible differences there are then as far as the requirements that the secretary's office, if they're sending something out versus an organization?
Well, as I understand it, the secretary of the county election officials would only mail out the official application for an advance voting ballot. I believe what that provision is getting towards is requiring any other private individual organization to do the same, so that the voters receiving the official application for an advance voting ballot. But those requirements in terms of the mailer requirement and the labeling and the return address envelope, those are only applicable to private individual and organizations.
Okay, and then I guess part of my question with that is the very bottom line, no portion of the application can be completed prior to mailing. Like I've seen in the past, some of these forms come out with the address pre-printed for the person it's being sent to, and that comes, I think, from the Secretary of State's office as well. So do you think the interpretation is there that the Secretary of State's office can pre-populate that information, but other organizations can't? I mean, and it's public information to some degree.
Yes. I believe the Secretary of State and the county election officials are free to populate such as the address of the voter in the application when they send it out. The restrictions under subsection K are only applicable to private individuals and private organizations.
Okay, thank you.
Any further questions or comments? Oh, Senator Frasco.
Mr. Chairman, thank you. Sorry for my tardiness. I was listening to a constituent where her children, St. Francis, are removing her children, so I had to help with that. Mr. Chairman, since these are election bills, so why are we having the hearing here? You know, I actually serve on the election committee, and so.
We're just having an informational overview of the bills we passed last year and where they're at and what's going on.
Okay.
So these are not hearings, but I think my understanding, some of these bills come out of here, so, and there's going to be election bills come to this committee, so.
Oh, so
Just try to get some background of where we were last year, where they're at and everything.
So just kind of the overflow of election
Overflow,
bills.
yeah.
The overflow of those election bills are coming to Fed and State for overview. That was a tongue twister, Mr. Chairman, but I do have a quick question for Jason. So don't we already currently retain that information of one's residential, so it's saying the residential and the mailing address, don't we already do that of what's in this?
As I understood that issue from last session, there was recording of a residential or mailing address, but there was some difficulty in getting complete records from both addresses from the state office. And so the solution proposed and adopted in the bill was to require each county election official to maintain both a residential and a mailing address for each voter.
So, Mr. Chairman, Jason, so like myself, I have a physical mailing address. I also have a P.O. box. So you're saying I'd have to give both of those?
Yes, under the bill, the residential address must correspond to where you reside as a voter. And that could be the same or it could be different from what you provide as your mailing address to receive mail.
I see. Thank you, Mr. Chairman.
Any further questions or comments? Okay, thank you, Jason. Move on. You want to talk, Jason, you want to talk about the student athletic bill? I believe that bill's below the line, right?
That's correct.
You know, a couple of my people I've talked to in the halls, is there a need for this bill even now after what the NCAA did? Or would we actually be just muddying the waters? I don't think there's a need for the bill. That's my understanding. That's probably the question I'd have for you. If you want to do a little background, then you could tell us what they've done to your best of your knowledge, and let me know.
Well, yes, Mr. Chairman, members of the committee, I know there is no federal law on this issue that would apply nationwide. I know several states have passed legislation similar to this to take care of these situations in their own state with their own state universities and colleges. I believe the NCAA has taken some action with respect to this issue. I cannot speak to the particulars of what they have done. I would have to go back and do a little research on that. The bill would codify in state law student athlete contract rights with respect to their name, likeness, image, and athletic reputation. So if the NCAA ever changed their policy or revoked their policy, there would still be state law in Kansas for student athletes who were attending college or university in the state of Kansas. But I can certainly go back and see what the NCAA has done and report back to the committee on that.
I think you might want to refreshen yourself on it, because I think this is probably not needed, but Senator Longmire, go ahead.
Thank you, Chairman Olson. This was a subject matter that I have been up on. These bills were introduced in a number of state legislatures last year and the previous year due to the inaction of the NCAA. And I think what the NCAA found was that they were forced into action by kind of a hodgepodge of different state laws across the country. And so the NCAA has adopted a name, image, and likeness policy that any member institution has to abide by, so that it is uniform and fair across all state lines. So certainly that's not prohibited to have states enact legislation, but I'm not sure that it's going to serve any purpose, because if you're a member of the NCAA, which almost all institutions are, they have to abide by the policy. And so I don't know that this is needed at this time. It was more of a reaction to the inaction of the NCAA last year, but they have responded since.
It's kind of what I've heard too, and I thought maybe if you and Andrew kind of did a little background, but my thinking on this, I was going to ask leadership to bring this bill back, and I don't think it's needed, but I'll wait your guys' advice before we do any of them maneuvers. But take a good look at that over the weekend, or when you get a minute, and then, you know, let me know next week. And it'd probably be good to give us a little one-page briefer on what they did, so the committee has a full background. So, any further questions or comments? Come on, Senator Reichman, you. What's going on in Colorado now? And Oklahoma. Well, with that, we do have one more bill introduction. Senator Hildebrand.
Thank you, Mr. Chairman. I would like to introduce 22 RS 2469, the Community Defense and Human Trafficking Reduction Act.
Okay, I'll second that. And is there any objection with Senator Fasco-Deau?
Oh, I don't object at all. I just had a question. Can you just elaborate a little bit on the last part of that? You said can you repeat that?
Community Defense and Human Trafficking Reduction Act.
So the reduction part, would it elaborate on that?
try to reduce human trafficking.
Well, yeah, but we're already doing something similar. I mean, and legislation has come before, so adding that additional word, your hope is to, I mean, because over the years, we've had these type of bills that have come.
It's not his bill.
Oh,
I
okay.
apologize, it's not mine. I was just asked to introduce it, so.
You know,
Thank
some
you.
people just bring bills to us and
Yeah.
we're trying to allow people to introduce their bills, so.
And Mr. Chairman, to the Senator Reichman, I understand the word reduction very well, but, you know, when you've been around this building for a while and you hear certain bills come and introduced over and over, you know, sometimes people will tweak it a little bit and add something additional in there to get a better response. And so since the Senator Hildebrand but he's introducing it for someone else. So if it comes to the Senate floor, I'll get a better answer. But thank you for, I appreciate giving you a laugh or a chuckle.
Or committee. Senator Hosher?
Yeah, kind of along with that question, is there a sponsoring organization that it was forwarded from?
You know, go ahead, Senator Hildebrand.
I'm not sure. I was just asked to present it from our chair, so.
Yeah, I was asked to introduce this. If there's any other questions, normally it's not a problem to introduce a bill. Then it gets, you know, once it gets, the report gets submitted, then it'll get a number and then we'll see if it gets a hearing or not. So, is there any objection anymore? Not seeing any. The bill is introduced. Okay. With that, me and Senator Hosher, we're going to be at a game today, so I hope my side wins, but I'm just going to state that. We will see everybody next week. Have a good 4-day weekend, and we are adjourned.